Good morning, everybody. I'm David Sterling, Chair of the Chief Executives Forum. It's good to see so many of you here today. This is the first time we've experimented with this hybrid type arrangement whereby we've actually got some people in the room and also some people online. This is another in our series of exit interviews, which have always been very popular with our membership. And I'm particularly delighted this morning that we have got the former Lord Chief Justice, Sir Declan Morgan, who's going to give us some insights into his career. And hosting the event and managing the questions, again, will be Nick Corbett, who many of you will know, and who has performed this sort of service for us on many occasions in the past and done it extremely well, if I may say so. So look, I'm really looking forward to the conversation this morning. And we will be recording this, so it will be available at a later stage. We do want this to be as interactive as possible, so please feel free to use the chat facility to put forward any questions that you may have. But for now, I will hand over to Nick.
Thank you very much indeed, Sir David, and hello and welcome everybody, particularly to all of you online. And just to reinforce that, we're probably not going to be able to allow too many interruptions, as it were, just because of the hybrid nature of the event. But please do use the chat function there, and we'll get your question addressed to Sir Declan as soon as we possibly can. So I'm going to say very welcome to you, Sir Declan. It's great to have you with us, sharing your insights. And I'm going to start with maybe asking you a little bit about your values. So I was hoping that you might be able to perhaps explain to us a little bit about what attracted you to the law in the first place, and then maybe what sort of animated you as a lawyer and then a judge and then head of the judiciary. In other words, you know, is being a judge and head of the judiciary a bit more than just enforcing rules?
Yeah. Well, I suppose I should start at the very beginning, as it were, Nick, as maybe a good start. As you know, I went to St. Colum's College in Derry, and I walked to school and back every day. And my walk took me past the walls into the city and then down to where I lived. And I knew as I walked along that on the big building on my right-hand side was the jail, just on the outside of the walls. And that inside the walls, there was another big building, and I had no idea what it was. And that remained the case through until I left St. Colum's College at the age of 18 or 19. In other words, I did not know that the big building was the courthouse in the city. So I can't say that my aspiration, as it were, to become a lawyer arose as a result of my proximity to that particular building, or that the work that was going on within it. I was one of, from our school, St. Colum's, the first 3 people to go to Uxbridge. Our president at the time was, I think, very focused on generating what were intended to be, if you like, future leaders within the community, or people who were going to contribute in some way or other to the community. And there was, you know, a sense of obligation that was, I think, alive at that time. I mean, I was leaving school around 1970, 71. The civil rights movement was very active at the time. All of us participated in that, and there was a sense of contribution to the community, of obligation to see through, as it were, the values that the Civil Rights Association was promoting at that time. So I went to Cambridge not as a potential lawyer. I went to Cambridge as a mathematician. I was a competent enough mathematician, but I was never going to set the world on fire. And one of my friends, also from Derry, was doing law, and he seemed to be having a great time, thoroughly enjoyed it. And I thought, I mean, I didn't make up my mind about this over the summer at the end of my first year. About 2 weeks into my second year, I went along and said, look, I really think I'd be far better off doing law. So I went into second year law. My degree consists of 1 year's mathematics and 2 years law. I still didn't want to be a lawyer after that, although Cambridge for me was an eye-opening experience. I mean, I came from, a rather insular part of Northwest Ireland, and I was faced with, things that I'd never experienced before, and people who were individually, hugely interesting and amazingly capable. And it really opened my eyes in certain ways. Not, I have to say, in terms of making me a mature adult, because I'm afraid I was one of those young men who simply didn't come to hand until about 30 or so. And it's quite normal for those of us who are parents to understand that with boys, there's always, or can be, a bit of a problem about getting them organized. And I was no exception, I'm afraid, to that rule. And I think in a way it probably did me no harm, because the more mistakes you make, the more you learn. And I probably made my my own quantity of mistakes. But undeterred by having done my 2 years law, I then went down to the city in London for a short spell as a trainee accountant, which I thought was terrible. I hated it. Came back home. At the urgings of my dear mother, God bless her, I thought I'd better do something useful, like the bar course. So I did the bar course coming out in 1976. And because by that stage I hadn't thought of anything else that I wanted to do, I thought I might as well pursue this for a while and see how we got on. And it was only then that I realized how much I enjoyed it. And I enjoyed it because there was an opportunity in many cases to do something for people. You got the satisfaction of having somebody who had a problem, who'd come to you, who needed a resolution, either individually or organization or whatever it may be, and you were able to take them through that. And also there was a sense that people that you were engaging with often hadn't experience of courts or lawyers, or weren't entirely sure how everything worked. And you needed to use your people skills in order to both understand what it was they needed from you and explain to them what it was you could do for them. And there's a huge amount of learning, I think, that you get from that. I mean, as a rather immature 20-something, I think all of that helped to make me understand so much more about the people with whom I was engaging, so that I was getting two benefits out of it. One was technically I was learning, because every case I did, I got something positive out of. But I also learned a lot more about people, about people's needs, circumstances, about their some people's fear almost of law, because it is so, for some people, intimidating, and the need to, as a lawyer, when you had people who you were coming across, whether they were in an organization or individually, to understand all of that and to engage with them on that basis. So I suppose that was part of understanding the need for collaboration, if you like. And I enjoyed my time at the bar, and I continued, I felt, to benefit in all sorts of ways from that, in the ways that I've indicated. Took Silk in '93. An anecdote, when I, just before I was called to the bar, my father said to me, look, and we're in the middle of the 1970s, and he said, look, yes, it's great you're going to the bar, but you must promise me that you'll not go on the bench. And the reason for that was that 2 years beforehand, my mother's cousin, Rory Connahan, had been shot dead by the Provisional IRA. And he was genuinely worried that that I might find myself in the same situation. And I went into the bar confident that I would adhere to and stand by and that promise that I gave him. And for me, the thing that changed that was the 1998 agreement, because the 1998 agreement was about asking people to make their contribution towards moving this community on. And that was the stage at which I felt that I needed to think about whether or not there was a contribution that I could make to that. And in 2002, the position of Senior Crown Counsel came up, which, as most of you will know, is a route towards the bench. And I applied for that, not having gone through the usual route of Junior Crown Counsel and then up, and was fortunate enough to succeed in that competition. And then in 2004, went on to the bench as a High Court judge. So going on there, I mean, I was taking all of those thoughts, if you like, with me about recognizing that the people that we were coming across, for them, their event in court, if it came to court, was something with which they might be entirely unfamiliar and maybe very challenging for them. And that we as judges had a huge responsibility to see what we could do to ensure that we could do what we wanted. And what we wanted was to ensure that if you were in court, that you had the opportunity to give the best evidence or give the best account that you could. And that was our obligation. And throughout my time in the bench, I think that's what I've sought to do. And I think I've made, some modest changes to the way in which things happened. I mean, in the Court of Appeal used to be perhaps a rather formal court where parties would make their oral submissions. In truth, the oral submissions often reflected what they'd already told us in writing anyway, and I often wondered, what's the point? And there would be the occasional interruption from the judge questioning, but it would have been gentle enough. And certainly in my case in the Court of Appeal, I thought this is not really the way to go. I mean, we've read what you have to say. The issue that we have to determine are the bits that we need to explore with you to see, and we need to give you put the questions to you, the problems to you that we've spotted that you maybe haven't addressed. So by the end of it, there was one particular or two particular counsel in the Court of Appeal who, instead of taking the usual route of the submission, started off their submission by saying, "Do you want to start, my lord, or will we?" And I thought that was great. I thought they've understood what we're there to do. What we're there to do is to try to find the right answer. And they're there to help us to find the right answer. And we're all, I mean, if I can dare use the term, in this together. And in trying to find that right answer. And although they have, a side to take, their duty to help us get the right answer is greater than their duty to try to win the point for their client.
I have to say that's a really fascinating perspective. So you've sort of effectively redefined yourself as a public servant, and that's really what's motivated you all along.
I think that's right, and I do think the 1998 agreement was very important in my head in understanding that there was an obligation that came from that for all of us to think through what we could do to make a contribution. And certainly in my case, that was what caused me to reflect on the promise that I made to my father, who by that time was deceased, I'm afraid.
Gosh. And can we talk about, I wonder if we could talk a little bit about the nature of your office and sort of legal gravitas, if you like. And you were talking about presumably wanting to be very approachable to people in the court. And yet there is something, I suppose it raises two questions in my head. One is, and I'm just going to be perfectly frank with you, in fact, I mentioned this to you before, I did find the prospect of doing this interview with you before I'd actually met you really quite intimidating, just because of the nature of your office. And so how do you actually balance the gravitas, the distance that you need to maintain as a judge, with that need to be accountable? And how does that then translate into, some of the court rituals, wigs and gowns and the rest of it? I mean, how do you address that?
Well,
do you feel like you're
intimidated? Oh yeah, no,
yeah.
definitely. I mean, I made some changes to the way in which we dress, modest changes, I have to say. I mean, we don't wear wigs in criminal cases or in civil cases anymore, but we do wear a gown. We don't wear any gowns in family cases. We just do them in our suits. But I think that what I'm conscious of is that there is, I think, a need for a degree of formality in a court setting. It isn't, and the formality is there to help people as well as maybe to. It may have the effect of intimidating some. The help is to make people aware that there's a seriousness to the contribution that they may make to the case. I mean, at its worst, if somebody tells something which they know not to be true, they may go to prison as a result of that. I often think it's quite similar to going to church. I mean, some churches are rather more formal in the way they do things than others, but there's a sense of having to understand that one is in a process that has some formality to it, which imposes a duty to be, to be careful that you are, if I can put it that way, helping in whatever the case is. But the other side of that is that, particularly for people who are not regular litigants, it's a very intimidating prospect, I think. I once was involved in a road traffic accident and had to give evidence. And I was a barrister at the time. This would be no problem whatsoever. It was really, you felt totally isolated up there once you're in the witness box. And it's peculiar how, as a counsel, I didn't see that at all. And that was one of my big learning experiences. You're sitting there and you're doing your best, but you're nervous that your best isn't good enough, that in some way or other, you answered the question in a way which was misleading or misinterpreted, or deliberately misinterpreted, even worse. But not that it really happened that way, but I having been through that experience, I think was for me extremely helpful in understanding just what litigants who are coming into court for the first time, with maybe the case depending very much on how they perform. I mean, the pressure on those people, I think, is enormous, and therefore part of the process has been about the ways in which you use your personal skills to make people feel comfortable. So you talk to them, you get to sit down, you tell them a bit about what the process is going to be. I think sometimes if you can introduce a bit of light touch into the event at an early stage, people understand that they can be a bit more comfortable. And I think sometimes you need to look at the witnesses as well to just to make sure that they are comfortable, and to pick up on if it is the case that they're not. But there is always bound to be a degree of formality, and that's all the more so in cases, in criminal cases, because of the consequences that there are for those who are involved. But I do think our obligation is to make sure that the person who is coming in to give evidence in court is put in a place where they can give the best evidence that they can. And there are all sorts of ways in which we do that. certain types of victim.
Okay, that's actually probably given us a bit of insight into my next question, which is really about something we've asked everybody really in this series about leadership, your personal leadership style, what you think makes a good leader, characteristics that you recognise as being typical of a good leader, and I suppose the importance of soft skills as well in leadership.
Well, I suppose this is an opportunity for me to acknowledge that my two chief executives, as it were, of my past life are actually present in this room
so
today.
It's your turn to be intimidated.
Of course, they were important to me because there was a lot of, well, I agree entirely with what you're saying there, but I'm not sure that people will understand it. And maybe we could use this way of doing it. So from their point of view, they're probably sitting here to see what it's like when I'm let loose in my own, as it were, without the appropriate restraints applied. But it does give me an opportunity to thank both Manny Kilpatrick, who was my PPS as Chief Justice, and Tanya McCormick, who is my Chief Executive in NIJAC, for the help they gave me in reining in my more adventurous aspects of what I wanted to do. But going back to the question we were looking at. Leadership. Yeah. Well, this is a bit of a sore point with me because, what do I lead? I lead my 71 odd salaried judges. Technically, I don't lead any of my support staff because my support staff are all being led by the department. I'm the only Chief Justice, or was the only Chief Justice in the United Kingdom, or in fact the British Isles, who doesn't lead the support staff and who doesn't have the ability to be able to define the direction of travel in relation to the way in which the support staff should be allocated in order to improve the way in which business is done. And that, for me, is a sore point. I have pushed this throughout my time as Chief Justice. I keep being told that there's no political appetite for doing it. I'm not sure that that's right. I think there's been no attempt to persuade politicians. And I think it is, maybe in an understandable way, a product of the fact that justice was only devolved here in April 2010, and that it takes time for confidence to build up within the department, that it's safe to give that operational responsibility to someone else rather than to have one's finger in charge of it. So that meant that in terms of leading, and insofar as I could, the justice system, the leadership that I was to give would necessarily involve what I think people call soft power. In other words, I had to engage with the other stakeholders with a view to, some of whom are here today, like Stephen Heron, to seek to achieve through them the outcomes that we wanted to achieve. So I'll give you an example of the sort of thing that we did. In the early teens, I became concerned about the number of short prison sentences that were being handed out by the courts. And also the fact that in many cases, people were time served, possibly as a result of having been remanded in custody, and that they were walking out really to do the same thing again. And there was a pattern of repeated offending. And I felt that we really needed to think of whether there was another way of doing things. So I got Cheryl Lamont, who was then the director of the probation service, to come in with Geraldine O'Hare, and we talked through what the probation service might be able to do. And they were very positive. I mean, obviously, I gave them a hard sell, as it were, as to what all of this could manage, and persuaded them that they should do a pilot of what subsequently became the enhanced combination order for people who, as an alternative to a sentence of 12 months or less. And they were prepared to do that as a pilot out of their own funding, that, you know, whatever reserves they had hidden away in certain locations. But the next step was then to persuade the department that this was a project that, one, was worth continuing in terms of providing the funding to continue it, and two, was worth developing on a Northern Ireland-wide basis. So you have to use your skills, as it were, to bring people in at the right time. To some extent, bringing the department in after we'd set up the enhanced combination order through the probation officer's own resources meant we could show them product. And once you're showing product, and of course we'd had it statistically looked at and saw that there were advantages there, then we could move on to get the department on board. Now, I mean, that's just a small example of things that we did. Other examples would include, for instance, the indictable cases pilot. There's a huge problem in Northern Ireland about delay in Crown Court cases. The problem is, at least in part, due to the arrangements for bringing these cases to the attention of Crown Court judges who can then manage them as soon as possible. So we tried to work out how we would approach that, and we used funding from my office to get somebody who had been in the Criminal Justice Inspectorate to come in to do a report about where we could make improvements, which we then took to the Criminal Justice Board for discussion. We managed to persuade the department, the PPS, police, that this was worth progressing because we could see advantages there. We put this project into action in 2 locations. The locations in which we did it, needless to say, happened to have the 2 most robust judges that I had available to ensure that they were going to do the business, and they did. And what the product showed was that you could cut the time spent in magistrates' courts by maybe 50% or more if you approach things in a certain way. Now, the downside, if you like, from that is that where you've got a pilot of that sort, the difficulty is that sometimes everybody puts their best people in there, just as I had done. So the best people on the police side, the best people on the PPS side, etc., were all involved there. The forensic people gave priority to what was doing. And to some extent, you need to then understand that when you go to roll that out, it doesn't work in quite the same way. And there were lessons there for me about understanding that you need to be very careful about using the pilot as a way forward. A much more constructive way forward was to change our rules on committal, the way in which we send people through to the Crown Court. And from about 2012, I had been trying to persuade the department, PPS, police and others that that was the way forward, that we should abolish committal in relation to indictable cases as a matter of principle and move into those cases going directly into the Crown Court. Now that was going to have considerable consequences for the PPS. It was going to have considerable consequences for the PSNI. It was going to, in effect, change priorities, because it would have meant that more priority would have to be given to Crown Court cases. But the department accepted that there was a strong case for it, and they brought forward a committal bill, and the bill produced an act which I'm afraid was unworkable. And the reason it was unworkable was it was butchered in the Assembly. And that's one of the things I'll maybe come back to, but it was very interesting that the Department of Justice can't put a whip on anybody to put their proposals through. Our governing system doesn't enable them to do that. And I'm going to, this is an ad for the Government Legal Service discussion on Thursday, but I'm going to go back to the issue of devolution and justice. And the subheading is it desirable or necessary to have a review of the way devolution is working in Northern Ireland, with particular reference to justice?
If I may, I'm going to ask you, I'm going to come back to that because I think it's a really, really interesting and important topic. But just before I do, whilst we're sort of talking about leadership and how you exercised it, I wonder if you could share with us some insights into that. I think a challenge that every leader, particularly emerging younger leaders, face, because to my mind, people in leadership roles are probably under more intense pressure than they've ever been before. It can feel very lonely. The stresses of it can be enormous. I'm wondering if you could perhaps tell us a little bit about how you coped with the stresses and pressure. Give us an example, if you like. It won't land anyone in court. And also, I suppose, what advice you'd give to an emerging generation of how to cope with all this.
Well, during my time as Chief Justice, the most difficult period that I had was a 7-month period during which I did not have a PPS. I'd had a number of candidates offered to me that I didn't feel were suitable for the post. And I was getting to the stage where I felt that there was something personal between me and the person who was offering them. But such is life. I found that very difficult. And I understood from that something about the way in which I was leading. And my leadership was, I was going to say collaborative, but it's not quite what I mean. When I was a senior counsel, I always made my juniors work in the sense of getting them to think about the case and help me to work out what was the right way of doing it. And when I got into a leadership role in both the courts and in NIJAC, I used and expected my chief executives or PPS to be the person who would work with me and help me to get what we thought was the right answer. So my point is that I didn't feel, as a result of that, I didn't feel isolated because I had somebody else with whom I could talk through everything without any restriction or restraint, and somebody who had the experience to be able to say to me, that won't work, or that will work, or maybe we can make it work in a different way. That I think was, I realized was extremely important to me. To be on my own as a leader, I think I would have found it possible in the longer term. But to have, and I had 4 excellent PPSs and 2 excellent chief executives of NIJAC, and I was very lucky in that respect. But those relationships were absolutely critical to the way in which I was able to do the job. I think in terms of the wider leadership issue around, the public space, I think their collaboration is hugely important. I mean, my predecessor had declined to participate in the Criminal Justice Board because he felt that judicial independence meant that there had to be a distance, and I know that that's something that you were asking me about earlier. But my line on this has always been that judicial independence didn't mean judicial isolation. I mean, judges have a huge amount to contribute to the way in which the justice system works. We have a perspective which is different from that of others. We need to bring that perspective into the system as a whole, so that they understand, what it is we're seeing and what it is we think we need to have put in place. And we need to hear what other people have to say about that, because one of the effects of living in a soft power environment is that if I decide, that from the judicial point of view, something or other would be a great idea, I need to make sure that I go to Stephen and find out from Stephen, what's that going to mean for you? And how is that going to affect your organization? And are there things that I can do, carrots that I can give you in return for getting this thing done? And that type of bargaining with the other bits of the system to make the system work is absolutely critical to being able to deliver. If you can't do that, if you can't make that deal, if you can't identify the issues that the other bits of the system have to cope with, I mean, you're wasting your time. And that's why, from my point of view, collaboration as a way of achieving success was absolutely critical.
Fascinating. That's probably quite a good way of moving on to something which must have caused you a considerable amount of stress and pressure, I would have thought, and that's the outbreak of COVID-19, the impact on the judiciary, the impact on the court system, the impact on victims of crime, the impact on alleged perpetrators of crime, what you learned from that, and what difference it will make going forward.
Yeah. Well, I mean, it was a nightmare for everybody, I think. There's no point in pretending otherwise. And, it was as though you got into the ring and some heavyweight had come along and just bumped you. And that was the initial scenario. I remember at the very, very start of the pandemic, we had a jury panel due to arrive in Derry on the 18th of March. And if you remember, things were going to close down on the 20th. So I talked to my PPS, said, I think we should cancel this because, this is not going to go well. And she made some inquiries and came back and said, look, department is really anxious that this should go on. I think we should just leave it to them and see what happens. She was quite right, of course. The jury panel, amazingly enough, 48 people turned up for the jury panel. And Judge Babington went out and said, thank you very much for coming. Are there any of you who would have difficulty serving in this jury? And 48 hands went up. So that was the beginning of the pandemic. It was interesting because of the leadership arrangements that were flowed from that. In England and Wales, the court service, which has the Lord Chief Justice as the joint head with the Lord Chancellor, issued guidance as to how you should do things and where you should go and how the courts were to work, etc. And we, through Mandy as my PPS, took that on. We weren't asked to take it on, we just took it on because we knew we had to do it, despite the fact that my responsibility was only for the judges who were actually sitting there, not for, and I suppose I had responsibility for listening, but I didn't have responsibility for the support staff. And we needed to make sure that the arrangements we were putting in place were arrangements which were going to be suitable and satisfactory for them, as well as for Stephen and for others. We managed to, I remember I did my first case in the Court of Appeal in the middle of May, which we did a criminal appeal, which we did remotely. It wasn't hugely satisfactory. The technology, was just about all right, but not much better than that. We had our first hybrid hearing in the Court of Appeal on the 1st of June, where we brought the lawyers into court, but everybody else on the screen. Really, from then on, the Court of Appeal was open for business. We were conscious that everything that we did had to pass the Public Health Agency. It had to pass the needs of the G4S who were involved. It had to pass the requirements of the other players, such as the PPS, DLS, and other people who were regular court users. And we managed to get the Crown Courts back up and running by August. And it was, you were going from week to week to see what you could do to try to make things work. I think there was a high degree of collaboration among all the agencies which were involved. I think it was good for all of us from that point of view, that we all appreciated that we all had different issues that had to be addressed, and we had to move at a pace which was going to enable everybody to be able to respond. There was no point. I mean, it's easy for me. I can say, well, I've got 71 judges and I'm now going to allocate them and they will be there and you get on with it and, and do your bit. But there would be no point at all in my doing that if I hadn't worked out that the prosecutors could be there, that the defence were going to be able to handle it, that the witnesses were going to be able to be available, that the PSNI were going to be able to service the issue, that the court staff felt comfortable about providing what was going to be provided, and that the technology was good enough, and if it wasn't, that there was somebody there I could talk to make sure that it was. So all of that, I think, accorded with the view about collaboration, which I'd formed quite some time ago. And actually on that, I think one of the things, just as I learned through my time at the bar, I also learned hugely during my time as a judge, but particularly as Chief Justice. I mean, you do learn in the job about the importance of things like collaboration and the importance of working with other people. It maybe takes you a couple of years to realize that you have there are no levers that you can actually pull to make things happen on your own. The only way you can pull that lever is by getting a whole lot of other people to help to pull it at the same time. And I think we did that with the criminal justice system. I think managed to achieve what we had hoped to achieve in relation to magistrates court business, which I think is more or less now back where it was. We had a problem with Crown Court business because social distancing meant that that we were going to have to physically reorganize the courts, and whereas we would have had 20 venues for Crown Courts, which would have enabled 13 Crown Courts per day to sit, we by the end of 2020 only had 8. And it was inevitable, therefore, that we were going to have a backlog, and it wasn't unusual. Scotland had the same issue. England and Wales obviously had that sort of issue as well. We hadn't such when we started off in March, we hadn't got the kind of backlog in the Crown Courts that England and Wales had, although we had this problem about cases sitting in the Magistrates Court that were going to come up. But we have gradually worked up, and we now have 15 Crown Court venues, I think. The last 2 just coming online very recently. And that means that we should start to see from now on the outstanding court list coming back down again. Now, oddly enough, we had actually had some experience of what it's like to have a backlog suddenly appearing, because back in the 2015-2016 period, there was a row between the professions and the Department of Justice about legal aid fees, the effect of which was in March 2015, the professions down tools and said they wouldn't deal with any Crown Court cases. So from May 2015 on, cases were being returned by the Magistrates Court to the Crown Court, and they sat there. Nobody was doing anything with them. The courts couldn't operate because people weren't represented and required representation and couldn't get representation. And that continued through until February 2016. And I take a little bit of credit for that resolution, because there was inevitably litigation over this issue, and the litigation was due to be heard in the Court of Appeal in January 2016. And a couple of days before the litigation, I sent an email out to the parties asking whether anybody had thought about mediation. And it actually got them both off the hook. And each of them was able to say yes. and they went and about 3 weeks later sorted it out at a mediation.
That's great.
Then John Larkin said that government isn't allowed to mediate because government has duties, and therefore it can't be bound by the mediation. So we managed to get over that as well.
Sorry, I'm interrupting there mid-flow, but just one thing that I think I find very helpful, and I'm sure quite a few of us who are not actually lawyers on the call would find interesting, is the point at which delays to the administration of justice themselves become unjust.
Yeah.
So I'm thinking about, for example, prisoners who are on remand or somebody who's got a thing hanging over them and victims as well. So at what point does that become a really serious issue that we should be concerned about collectively as society?
Well, I suppose my answer to that is that we shouldn't only think of it as a serious issue when we get to the point where it actually becomes almost unlawful, and I'll come to that in a moment. The answer to it is to make sure that your system actually ensures that you never get there. And it seems to me that we could do that. At the moment, there's a justice bill going through which actually is addressing committal. And so 10 years on from 2012, when I've been pushing this with David Ford, it's possible that we might get an answer, and that will have a significant effect on the issue of delay. It will also have a significant effect on PPS because there will be a reprioritization which will have to follow. Similarly on the PSNI, also on the forensic service. Whether this is like the climate change conference, whether everybody's actually going to do the bit that's necessary in order to achieve 1.5, I don't know. But I mean, that's the challenge that I think the justice system will face over. And I'd like to come back to that in the rape context later if we can,
surely.
do that.
Yeah.
But one of the difficulties with the committal arrangements is that sometimes cases, for a whole host of reasons, stay in the magistrates' court for a very long time. And the European jurisprudence basically supports the view that once you hit 2 years where a person has been in custody without being convicted of anything, then you're reaching the stage at which the interference with that person's rights is probably excessive. And therefore, if somebody is in custody for that period of time, virtually no matter how serious the offence in respect of which they're charged, there's a high likelihood that they will be granted bail. And that means that you're sitting looking at the possibility of people that you think are actually quite serious terrorists, for instance, being admitted to bail in circumstances where the conditions are never going to satisfactorily ensure that they would be inhibited or prohibited from actually engaging in similar activity. So that's a hell of a good reason for ensuring that committal should work.
Well, thank you. We actually had a question, which I'm going to read out, if you don't mind, Hugh, from Hugh Widdis, who's head of the Departmental Solicitor's Office, who's asking you for your thoughts on the role of government lawyers, both in their interface with the courts and more widely in the system of government and in the rule of law.
I mean, I think that there is, having been senior Crown Counsel myself, I have always been impressed by the quality of the government lawyers that I've worked with, and also by the absolute commitment to justice, in the sense that the integrity and openness that as a government lawyer you have to engage in. I mean, if something has gone wrong, you as a government lawyer, you have to put your hands up and say this has gone wrong. There is no question of trying to finesse it. You have to come out with it, and I've done that on a number of occasions. And put my hands up, shown a document which actually blew my case out of the water, because I mean, I remember in one case in a planning environment, the judicial review applicant instituted a discovery application for records around the decision-making process, which we thought I won. Then I subsequently, there was discovered and I was shown a document which blew my case out of the water. And the document was shown the next day to the person who had lost the discovery application. And guess what? My case was blown out of the water, but rightly so.
Yeah.
And I mean, I think that one of the things that I am confident about in this jurisdiction is that government lawyers understand their obligations of integrity, and that they carry out their tasks, I think, with a high degree of public service and efficiency.
So thank you. Yeah. I'm wondering if we could move on to could be a very interesting area in your case, Sir Declan. That's unfinished business. You know, what would you like to have seen done that hasn't been done? What's actually, when you think back about your career and you think about things that are going on that annoy you, maybe we could have some of those, could we?
Yeah, I mean, the difficulty is trying to work out where we start. I mean, the truth is, Nick, you know, when you're in a job like this, there's always unfinished business. There are always things that are hanging around there that not generally things you haven't got round to. It's things that have come up, and you know, there's never a moment at which you can say, well, actually, I'm now going to, this date is the date in which I'm going to retire, and by that date, all the things that are outstanding are going to be done. It doesn't happen, and you can't expect that it will happen. But there are things that, I mean, as you can probably tell, I've been very disappointed that I wasn't able to persuade the department to release the reins in terms of being able to give the judiciary a bigger role in relation to operational support, because I do think that would have, we would have been able to do some of the things that happened in Corona a little quicker. Can I give you another example? And if there are any politicians on the line, this is not a criticism, and please don't think that it is a criticism. In 2006, just after I was appointed as a judge, one of the accountancy firms prepared a glossy on a physical court strategy. And it was a reflection of the fact that we needed, that we were existing in Northern Ireland in a court system in which a number of the venues were unsatisfactory. A high number of them, apart from those in Belfast, were not multiple venues or had a limited number of courts available. So you couldn't have groups of judges sitting together, for instance, in the Crown Court in some of those venues. And a need to ensure that we provided for the public an experience which they deserved to get if they were going to come to court. Now, very little happened as a result of that. I mean, we have closed some hearing centres in Larne. Similarly, in Bangor, I think some of the masonry was unstable there, so you know we had to do it. But we didn't really, and haven't been able to get to grips with trying to figure out how a court system should work. And there are all sorts of things that we could do. You know, we could start thinking about civil and family justice centres, which were going to be separate from the criminal centres. Also easier to put together in that they wouldn't require the same type of security arrangements that you would have where you need to have criminal courts. You could add in there as well some other agencies, particularly in terms of mental health issues around family, as to whether or not there were issues there that could be developed. Or on the criminal centres, you could look at involving probation as part and parcel of the arrangements within, you know, whatever the building was, and or possibly have the mental health element there instead. But I mean, none of that has happened. And the only attempt there was to close up some courts was back around 2015-16, started off by David Ford, and it wasn't for strategic reasons at all. And I remember talking to the Justice Committee about this. I said, you know, you're doing this because you want to save money. You've got, you know, a fantastic centre there at Old Town Hall Street, which is the perfect civil and family justice centre. Build a bit onto the back of it into the car park, and you would be able to provide all sorts of facilities, which would, you know, provide this as a centre of real excellence in this area. But instead, we close the bloody thing up, and you know, it's not available for anything. And it's not unusual to find, you know, so we decided we're going to close 6 centres. They're all still open at the moment, and I'm not going to go into the precise reasons as to why they're open, but the reality is that where the politicians are in charge of running the court estate and providing the court estate, the issue of how many first preference votes there are in a particular location where a court is situated, it becomes important. And the end result is that nothing happens. And that's exactly what has happened to us. Nothing has happened, and there is no serious attempt to stand back and look at the bigger picture of what the strategic court system would be. Now, there's nothing unusual about that, and there's no criticism of the politicians, because it was exactly the same in the Republic of Ireland, and it was exactly the same in Scotland. And those jurisdictions are broadly comparable to ours. And what did they do? They faced up to it. They recognized it. They recognized that the issue of building the strategy was very difficult for the politicians, for the reasons that I've explained, that their constituents are inevitably going to complain. And in each case, responsibility for the strategy was given to the courts board, which was judicially led. And the interesting thing is, in the Republic of Ireland, they had a formula, the Justice Department. When the TD for Tipperary North stood up to complain about the fact that the local courthouse had been closed, the minister had a line, and it was the only line that was given. The closure of courts is entirely a matter for the courts board. Sit down. And that's the only way in which you can do it, that the general strategy has to, I think, have some political approval, and it obviously needs money, so it needs to be resourced from the centre, but delivering it is affected in both of those jurisdictions now, and they both had enormous changes in their courts, is delivered by those independent boards. I'm going to use that example on Thursday when I'm talking about the issue of devolution. I think exactly the same issues arise in relation to our health service. That again, we haven't seen things happening in relation to their. We eventually managed to get the Bengoa report in 2016. Everybody thought it was a great report. They duly sat in their hands until COVID came along and was taken over. But you know, you're going to, the implementation of these things always creates concern within the community. And you know, you need to make a decision. Are you going to do it, or are you going to continue to operate in the same inefficient way? And if you want to do that, you've got to put the delivery into the hands of people who are outside the political process and maybe answerable in judicial review for the implementation of the strategy. And that's fair enough. I think in Ireland, as a result, I mean, they closed dozens of courts and they won judicial review, which they won. Scotland closed dozens of courts, and they, of course, had this issue around, they've got huge land masses, particularly in the north, and they had to think about, you know, how far away from a courthouse where you're going to be. What was the criterion? And the criterion was 2 hours. And it wasn't by public transport. But, you know, if you're going to do this, if you're going to make things happen, then you've got to understand that there are some people who are simply not in a position to make the decision that needs to be made, and be honest about it. Recognize that, and then hand it over to somebody who is prepared to take the judicial review case if it happens to come, but will implement the strategy to ensure the outcome which should result in a better service for the public.
I think we could all literally feel your frustration.
Shall I go on?
You may, but I think
Okay.
I just wanted to make sure that, because with time, that there were two particular issues that I think it would probably be great if you could cover, but ignore one or the other if you feel that there's something you'd rather talk about. I thought it would be quite interesting if we could hear a bit about you on legacy issues. From the conflict, and what your thoughts were about how that's all progressing or isn't, and what the consequences of that are. And the other one was around rape, as we were talking about.
Okay. Okay, I'm happy to talk about both of those. I think it's important to recognize that the issues around legacy in our community are never going to be solved by the courts, and we've got to get that out and straight. My responsibility arose on the 1st of November 2015 when I was made responsible for the presiding coroner. The legislation is quite odd. I have the responsibility of appointing the presiding coroner, and the presiding coroner has the responsibility of looking after the coroners. Doesn't say how. And of course, none of us has any responsibility for the support services, yet again, which are separately part of the department's responsibility. But I took the view that if I was going to ask somebody to be a presiding coroner in 2015, I really needed to work out what it was they needed to do, because although the department had generously decided that they should appoint me as the presiding coroner, they hadn't actually worked out what it was necessary to do to deal with the legacy inquest caseload that was already there at that stage. Most of it, the majority of it, having been referred to the coroner service by the Attorney General, and in one case by the Advocate General. I went through a consultation process. I went to Europe. I talked to Pablo de Grief, the UN rapporteur. I talked to the families. I talked to the other criminal justice agencies. I even made a visit down to Thiepval to talk to the army, that was quite amusing. They wanted to greet me and look after me and give me a good feeling, but they didn't actually want to tell me anything. We all understood that perfectly. We had a very agreeable meeting. But I mean, I'm conscious of the fact that a legacy inquest is the gold standard, if you like, in terms of an investigation into something which hasn't resulted in a substantial criminal investigation. And it costs, about, when you put everything together, it's about £50 million to do just over 50 inquests in relation to just under 100 deaths. And you can't do that for all of the people who've had, where there have been deaths which haven't had the quality of investigation that these days you would expect. And in many cases, the reason that you didn't have the investigations of that quality was because sometimes you didn't have the techniques that are available now. And sometimes, I mean, the notion that you were going to go into the Brandywell or up into the Cregan estate in order to carry out a detailed investigation in relation to some terrorist activity or activity involving the army, from my point of view, having lived in the city, I know is simply not realistic at all. Having lived it in the early 70s, no, it just wasn't realistic. And therefore, I've always been on record as saying that it seems to me that there is an imbalance in the way in which the investigation processes have gone. There are thousands of families who have not had any review of their cases. Well, there might now be just under 2,000 who have not had a review of their cases, which might or might not throw up something that should be looked at again, and in most cases won't. So I think there were, as I said in a recent lecture, I think there were two serious attempts to try to deal with legacy. One was Eames Bradley, which I think, I mean, bluntly, provided the way ahead. And it was unfortunate that the issue over who is a victim killed that stone dead, because the rest of the report, I think, just looks to me as though it's where we should be going. It achieves a balance between the interests of the community and the interests of the victims, and that balance lies in the nature of the investigation that Eames Bradley proposed, which was looking at the cases that the HET hadn't looked at, or those in respect of which there was additional information that the HET didn't have, and a 5-year time limit. And the 5-year time limit was, if you like, for the community, because it recognized that this was an issue which the community had to move on from, not the individuals. I mean, the individuals may never move on. And I having appeared for two of the people in Ballysandy who were injured, I'm very conscious of the fact that in some cases, you know, the people in Hillsborough, the people in Ballysandy, the people in Ballymurphy, probably most of them will never move on from the experience that they've had as a result of not even them directly, but somebody else being involved, because the media and the discussion, extent of the discussion, the community involvement, etc. But the community needs to move on, and that's where Eames Bradley recognised that 5 years was the period that should be given to this, and then it stopped. And as Dennis Bradley said, and Lord Eames agreed in an interview some years ago, in effect that was an amnesty, because short of somebody coming into a police station with their conscience and saying, look, I'm sorry, I murdered somebody, I want to tell you all about it now, nothing more was going to happen. Stormont House Agreement actually was much the same. Stormont House Agreement provided the same mechanisms, information retrieval, oral history archive, and the HIU. And the HIU again had in effect a 5-year time limit. It was, we're 5 years on from Eames Bradley, we're a bit behind, but again, we're going to do the same thing broadly that Eames Bradley suggested should be done. And that will be, we will have paid due respect to the interests of the victims and balanced it against the need of the community to move on. And I don't know why Stormont House didn't get implemented. I mean, the two governments supposedly were committed to it. The parties, some of the parties were iffy about it. I think that was a huge disappointment, because it would have given us, if it had been honestly adhered to, we would have moved on as a community from the past. We wouldn't have been able to provide any further significant political help to those who were suffering. They might have been able to provide, you know, mental health services, etc., to those who were continued to suffer, and of course, you know, some measure of compensation through the victim payment boards for those who have suffered. But we've had two chances to do this, and my great fear about the present proposals is, and somebody that I was speaking to in London on Tuesday told me he doesn't think they get through the Lords. But my concern about the present proposals is that well, first of all the parties are opposed to them. The trouble is they're all opposed to them for different reasons. There are groups who are opposed to them because they want to continue to chase after the terrorists who murdered their friends, and I can feel that. I mean, Rory Conaghan was my mother's cousin. I mean, nobody was convicted in relation to that. There were 4 other judges who were murdered by terrorists, and none of them, as far as I can see, were ever convicted. So I understand that, even both on a personal and institutional level. But I'm just trying to get the thread of where I was going. But I mean, it does seem to me that the real risk here is that if the government does succeed in getting its proposal through, my concern is that in 4 years' time, the European Court of Human Rights may say, sorry, this wasn't good enough. You made commitments to the Council of Europe. I've described some of those who want this investigation, because I looked at the legacy inquest and I identified 4 categories. And the category that I think is the most striking is the category of people who were branded as terrorists by the state and who have been vindicated through the inquest process. And Bloody Sunday and Ballymurphy are classic examples of that. So if you've got cases of people who the state has determined, deceased people who were determined to be terrorists, I mean, say somebody turned around and said my daughter was a terrorist, I'd be horrified. And the idea that there wasn't going to be an investigation into that and her name cleared in relation to that, I mean, I would, I'd be, I would be more than extremely upset. There would be a problem. And my concern is that, because you've got cases like that that are all part and parcel of this exercise, I can think of nothing worse for this community than suddenly finding that there was a finding that there had not been an appropriate recognition of the needs of the victim. I think that if you can get people signed up politically to something like the Stormont House Agreement, there are all sorts of qualifications that arise in relation to the strict Article 2 process. The European Convention is meant to be practical and effective. It's not just theoretical and illusory. So if you've got a process that really is leading to a community resolution, to reconciliation, some of the what appear to be rather strict case law of the convention actually will be moderated to respect that. And I'm sure that there are ways in which this could be done, which would be found comfortably to be convention compliant. But when I was doing the legacy inquests, I went over to talk to the Council of Europe and I said to them, look, I can't afford to have you come along a couple of years' time saying this is not convention compliant because of the effects politically this would have in our community. I just can't afford it. And the Council of Europe said they thought it was fine. I even spoke to some of the judges in the European Court and said, look, I know you can't tell me, but this is the broad structure. Is there anything obviously defective about it you can see? And they said no. And I think that's the exercise that we, if I was doing it, that's the exercise that I would engage in. So I think legacy for me, I think it's unfortunate that that legacy inquests have actually been implemented on their own, because I think that has created within the community a sense of a lack of respect and dignity for those who have not had their cases properly reviewed. And I think it'd be very unfortunate if those people did not have a method of doing that. And I'm not sure that the government's proposals of a police officer telling you that they've had a look and this is what they found. I'm not sure whether that's enough myself, but we'll see.
Thank you. So, and you were going to as well. Just I'm just sort of beginning to get a little conscious of time, although we are still fine. But to talk about your concerns as well, perhaps about rape and sexual assaults on women and how they're dealt with in the conviction rates.
Yeah.
So on.
I mean, first of all, for those who are complainants in rape cases, as we would call them within the courts, and those who are defendants in those cases, I mean, there's no doubt that the period of time it takes for those cases to get to court is a huge concern. And one of the things, I come back to something I was talking about earlier, when we had the previous backlog of cases from the legal aid strike back in 2015-16, we analysed what the consequences were, and the consequences were that because the sex cases tended to be the most difficult and time-consuming, they were pushed to the end. The low-hanging fruit was taken, and those cases ended up having a significantly longer time span than they should have. And therefore, in discussion with Stephen and others, I mean, we were conscious that that's what had happened then. We needed to learn the lesson. And therefore, we have sought to ensure that during this period, that the sex cases get their place in that they are being addressed at this stage rather than being pushed back further. But they will suffer like so many others. The point about committal reform in sex cases is that these are cases that need to be managed. They need to be managed because they're much more likely than most cases to end up actually being contested. And the earlier they get that management from the court, and the court managing is about, again, creating collaboration to get people to actually do the things they need to do to push cases on, then that becomes itself a feature which should deal with, improve the issue of delay. But there will always be delay in court cases, and it's going to be problematic for those involved. There are things that may work, such as pre-trial cross-examination. It's possible that that will provide some benefits as well. But I have been struck, and I don't know how many of you listened to the recent podcast that the BBC have put out, Assume Nothing Rape Trial. It makes very hard listening. It really brings home the extent to which rape complainants feel isolated within the criminal justice process. I also listened, I think it was last week, to another programme on BBC Two that was dealing with the same sort of issues on rape trials, and where exactly the same sense was coming through. And I think John Gillen did a fantastic report with proposed substantial reforms, all of which I support. And I'm disappointed that those have not been capable of being implemented rather earlier than I know he would have hoped. But I'm not sure they go far enough. I've come to the view that in serious sex cases, that the complainants should have their own lawyer from the start. And their own lawyer should be there to help them to understand what the process is, to be a point of contact for them when they're uneasy about what's happening, to be there to mark the homework of the courts in terms of the pace at which the case is going forward. So I think they should have the right to make representations about the way in which the case is done, to argue for the position of the complainant in terms of disclosure, where there may be questions as to whether or not it's right that the privacy rights of the complainant should be intruded upon, to ensure that the complainant knows the procedure. I mean, you do have to be careful about coaching. You can't have that, but that doesn't stop you making sure that they understand what the procedure is. To make sure that if there is anonymity, that it doesn't mean that the complainant is behind a screen and her picture is sitting on is behind the screen in the witness box, and her picture is sitting up in the court on a screen so that everybody can see her and identify her. To be there as a person in whom the complainant has trust to explain what the outcome is, and maybe even to, if it's found helpful, to make the complainant or help the complainant to understand what the outcome might be in a sort of a stand back basis. And I think, therefore, that the giving the complainant that lawyer at that stage with rights to make representations to the judge, but not to participate in the actual trial in front of the jury itself. So that, for instance, they would sit in the trial And if they saw something happening, for instance, material being introduced in respect of which the complainant hadn't had a fair chance to make representations, they could then make a representation to the judge to say, look, judge, I think this is unfair. If you're going to do that, then the complainant should be given the opportunity to talk about it. You know, things like that. And I mean, I know there'll be huge resistance. You know, PPS are not going to like somebody checking their homework. I mean, that's almost inevitable. The department are not going to like the fact that they have to shell out loads of dough for whoever is going to do this. But, you know, if you just listen to what's coming across, this is a real problem. And we have to try and find a real solution to the first bit of it, which is the experience of actually being involved. And the second bit, I think, is very difficult. And the second bit is around the extent to which it's likely that you will get a conviction. And part of that, I think, and I'm open to correction on this, but part of it, I think, is because in many of these cases, these are word-on-word cases, sometimes historic, no real forensic evidence either way as to whether or not any activity was consensual or otherwise, or believed by the perpetrator reasonably to be consensual. Sometimes there will be alcohol or drugs involved in the accounts that are given. And that's not to be judgmental, but simply to reflect the fact that that may affect the quality of the evidence and the quality of the recollection of the individuals involved, and therefore give rise to the potential for doubt about the accuracy of what has actually occurred. And it's that second bit, I think, that is probably the most important aspect of successful prosecution. And Stephen may have a better handle or experience of that on that than I have. But there are things I think we need to do to improve the experience. But I find it difficult to see that I could put my hand in my heart and say that these things that we need to do, and the implementation of John's reforms, I find it hard to put my hand in my heart and say that I think that these will make a material difference to the outcomes of the cases.
Goodness. Well, thank you for that. I have, I'm conscious, and I'm very conscious of time now. I have a question for you, from Louise Crilly from the Departmental Solicitor's Office. It's a great question, actually. It's a good one to end this section with anyway. What would you say to newly qualified lawyers to encourage them to stay in the profession despite the lack of work?
Well, I know from my point of view that in my first several years, I mean, I didn't make enough to cover my expenses. That simply was the way it was. And my parents weren't wealthy. I mean, I had to try to negotiate arrangements with the bank, which were always under constant review, as it were. And it was tough. But the reason I stayed was because I found something which for me was fulfilling, and I thought also contributed a benefit to the individuals with whom I was working, and I got a huge sense of satisfaction out of that. And I think at the end of the day, you know, if the level of satisfaction you get out of doing what you're doing is high enough, there are an awful lot of depredations that you'll actually both endure but accept in order to be able to continue to do that on a longer term basis. So, I mean, I think I would encourage people to reflect on how much they love what they're doing and how much good they think they are doing in what they're doing. And you know, to have a sort of cup half full attitude to what the future might bring. I understand that there are there are some people who go into it. I mean, I went into a fancy thing and there's be a breeze, and it was a horror story. So there are some people who are brilliant academics who will go into law thinking, well, the bar is just for me, or this is just for me, and think, God, it's terrible. And I understand that. And those people, get out, go and do something else, find what it is that actually makes you tick. But for those who have that sense of, what as a lawyer you can contribute, how you, are working in a way which also respects the dignity of the people with whom you're engaging. Despite the fact that you're in an adversarial situation, that what you do to the person that you're cross-examining in terms of respecting their dignity is just as important as the respect that you show to the person who's your client. That realizing that this is a huge responsibility that you have, and feeling that you can deliver that in a way which is going to respect all of those traditions. If you've got that, then you'll go through a lot before you decide to give it up.
Thank you so much. Anyone with a quick question before we close? No?
I think I would like to make it.
Yes, please, Stephen, do. Yeah.
We'll start with thanks, Sir Declan. You've been very open and honest and very clear.
I see the two ladies down there getting very nervous.
And that just absolutely talented me with how you were on the Common Justice Board. I have to say, you were always very good at making sure different organisations with different priorities try to think, maybe for the first time, about if I do this, what's the repercussion nature of it, and others, and there's no point to me trying to do this, and others trying to cope with it. So I get that, and I do thank you for that approach that you brought, and you found that right balance between the formality required in the position and the approachability, and I think that's shown today. But aside from delay, which has been a problem since 2012 and well beyond, what do you think the priorities should be for the justice system? We've struggled to align the priorities because we're all independent and individual pressures. But what should be the priorities for the system? I think, Sir Declan, if I can give you a pointer, we've often said we didn't want to be like England and Wales, where there's an agenda for more prison spaces, giving CPS more money, more police officers to get more people locked up. I think as a vision for the justice system, we didn't share that. What's your vision for the justice system in the next mandate?
Well, as you know, one of the things that I was focused on was whether we could achieve within the justice system an outcome which was comparable to that which one has in the Scandinavian courts in terms of our prison population. That was one of the issues that I was focused on, and I've talked to Ronnie Armour about this to see how it might be done. And my own view is that we have far too many people that we remand in custody. We should be finding ways of ensuring that they stay in the community, and we have no system at the moment for ensuring that people who are in this remand period waiting their trial actually are assisted in terms of dealing with their issues, be it drugs, alcohol, mental health issues, etc. So my suggestion to Ronnie was that what I wanted to see was the development of smaller centres to which groups of maybe 15 to 20 were remanded, which would be supervised by people who would effectively be there to act as mentors. The people in those venues would hopefully continue to work. They would be supported. They would get some of the types of assistance that is delivered by the probation service during the period that they were actually on remand, where there would be good supervision of whether or not their engagement with their previous pals, their alcohol, their drug abuse, etc., or their mental health issues would arise. And I think that would take those people out of the remand system, and it would create I think a diversion of money into rehabilitative processes at an early stage, as soon as they were actually engaged with the criminal justice system in relation to reasonably serious offences. And it would also help with sentencing as well, because you would see what was happening and the degree to which they were responding to what was being provided. And I mean, it seemed to me that that aspect of the justice system, I think there is a structural way of changing it. And actually, Ronnie and I had agreed that we would try it out. We were going to try it out on the women's prison. And the difficulty is the bloody women's prison is so good now that he said that there weren't enough of them there to be able to do this in any sort of sensible way. And of course, the women's prison has been one of the huge successes of our prison service in terms of what they were able to do. So it's back to the drawing board, and my successor will have to do what she can to try and persuade Ronnie to go in that way. I think there's another issue, Stephen, that is hanging around there for the justice system, and it's to do with structure in terms of making the system work more effectively. And I think that's about how we engage in the digital world. I think, we have digital systems like ICOS and Causeway in place, which were, 20 years plus there. I mean, they were at least 20 years plus because Mandy was involved, and I don't think it would have been any more than 20 years, but she was involved at the time in how those were developed. But we do need to think about whether the digital world gives us a chance to do things in a different way. For instance, just as an example, and I'll stop soon, don't worry, but just as an example, in the civil world, we do things at the moment by, you issue a writ or you issue a civil bill, and you then have formal pleadings and things like that. In the digital world, forget about that and forget about the court rules. What you do is you go on the app, you answer all the questions that you have to answer anyway on the app. And when you've done all of that onto the app, somebody triages your case to actually work out where you go and what's the most effective way of doing it. It's completely different. We have to stop using the digital world to execute the things that we executed in a physical way. We have to use the digital world to innovate in order to make sure that we actually take the benefits of that into the criminal justice system. And we need to make sure that if we do that we do it in a way that helps you, that helps the courts, helps the police, in other words, to collaborate to make sure that what we're doing actually with this innovation is something that makes decisive change in relation to the way in which the system works. But that's another lecture. Thanks, Stephen.
I think at this point we're sadly going to have to call it to a close because of people's diary commitments and everything. I have to say I thoroughly enjoyed listening to you. It was absolutely fascinating. You gave us so much. I hope you feel that you've had a fair hearing before we send you down for lunch.
Sounds as though I gave you far too much, and I'll be told that later on.
I very much doubt that. I thought that was fascinating. So thank you so much, Sir Declan. That was a really fascinating session.
Okay.
Thank you.
Thank you very much.